All right. You didn't hear it, but I gave a warm introduction to Matt. Thank you for being here. Matt, I'll let you take it away.
Very, very happy to be here. Thank you very much. I'm going to do that thing now where I share a presentation in the hope that it works. Let's see. There's going to be a little bit of sound. Can you all see this?
We do see it.
Good. Okay. So I just to be clear, I prepared something that's like a 15-minute presentation, and then we're going to be talking. I assume that's the right format. So I might have to skip through some of this. Thank you. Okay, amazing. Yeah, so thank you, Joshua. As pointed out, so I'm an artist, wear quite a few hats, work primarily with my partner Holly, who's in the other room with our son right now. And thinking about preparing for this, I'm going to speak a little bit specifically on this, on at least our conception of like a public AI or some of the work that we've been doing. But I thought it might be useful to give a bit of maybe a couple of provocations and a bit of backstory about some of the work that we do. So one of the provocations I start out with is this idea of saying that the most interesting opportunities to intervene in the future are barely visible. So the future looks like a regular human operating under a different protocol or a different operating system. I think that's pretty relevant when it comes to the public AI conversation. The other reason I bring this up is that it's important, I think, when I introduce some of the artworks that we work on, that we very much see. We've used the term in the past protocol art to describe what we do, largely because we're very, very interested in building systems upstream of the production of media, which is a provocation. But the idea here, I made these little memes, is that going back 10, 15 years, you could argue it's uncontroversial to suggest that the person setting incentives at Meta for the production of media, it actually has an overwhelming aesthetic downstream impact on the world, right? And maybe it's worthwhile also pointing out here that the idea of working on protocols is not necessarily mysterious to us because we largely come from an independent music background, which I think is mostly characterized by different ways of doing things upstream of the production of media. So there's a little provocation there, but that maybe qualifies some of the art projects I'm going to show you. So going back a long time, I mean, the first protocol I worked on was called Saga back in 2014. The whole idea there was providing an open and decentralized publishing framework for people to have more control of their work in a digital environment. I'll jump forward. We're probably best known for music that we released around about that time. So we spent a long time releasing records. There's on the left a record we released in 2015 called Platform, and on the right a record we put out called Proto. And the interesting thing about Proto that's most relevant to this discussion, I guess, is that we spent the period of kind of 2016 to 2019 thinking specifically about machine learning. Those of you who've like dipped your toes into training machine learning models will understand that the first question you ask there is what data do you train on? And so back in 2016, 2017, when we were working with admittedly primitive systems compared to today, we asked ourselves that question and thought, this is going to be a really big deal, right? Of course, our first instinct was, we could train on anything. Would that be interesting? Would it be interesting for us to train on a bunch of work that isn't our own? We came to the conclusion that perhaps it wouldn't be, that actually it would be more interesting to try and think of a different configuration to train models specifically for our own purposes on our own work and on the work of people who consented to it. So Proto was put together with the kind of suite of machine learning tools trained on a training ensemble that we put together. And the training ensemble included a bunch of different people who joined our band, so to speak, and also the general public. And so this is an example. This is a show in 2019 of kind of a group training performance that we did. And we've done many of these over the years, kind of inviting people to willingly contribute, in this case, their voices to a model greater than themselves. So I'll play a little clip. That one's kind of fun. I mean, I think that training corpus, we got to the point of like 50 to 100,000 voices that were consensually contributed to that, and of course make a really good model of groups of people drunkenly singing in a music venue, which is of relative utility, but kind of proves a point. Yeah, and then so fast forward a couple of years. We kind of started taking this idea of consent around data and kind of permissiveness around data really a bit more seriously, and started then focusing on the individual. We put together a project called Holly Plus. The idea there was to say, what would happen if Holly were to be more permissive with her identity, understanding that digital identity fundamentally is kind of a plastic thing. You know, I know Holly because she's the mother of my child, but most people know her from pictures on the internet. Most people know about as much of her as a model does, right? And so in which case that kind of virtual presence could be just given to anybody. So we came up with this term identity play, IP, to say that, you know, we're moving toward a future where it should be common for you to not only share data of yourself, but share the ability for other people to perform or make work as you. These are all plastic kind of fluid entities. So this is a performance from TED, I think in 2021, where we demoed a system that we put together to allow for people to sing in Holly's voice.
And with this microphone, you'll hear a live version of Holly Plus developed with Voctar Labs.
So the idea of Holly Plus, there's a website you can still go to now, holly.plus. You can upload an audio file and it will transfer your voice into Holly's voice. It still kind of holds up a little bit. But the main idea here, to go back to this protocol, was to say, in this particular case, how would you structure interactions around such an artist model? Where, let's say, you know, Holly's voice is free, anybody can use it for free. But in the instance that somebody wanted to sell something commercially, because publicity and personality rights kick in, this is kind of you know, separate from copyright. We put together a protocol where you could co-sell works with the permission of other people. So you're ostensibly kind of, you know, doing paying back to the person whose voice or whose context perhaps you are using in creating something. We've done some other works that I'll skip through here, namely, again, thinking about kind of embedding engineering or looking at the role of identities or concepts inside public models, right? Largely because, again, fortunately, given Holly's quite present in these models, like she's in clips, so you can type her name and do stuff. Kind of asking the question with the Whitney Museum, do we actually get to have some self-determination as to what our embedding or concept in these public models is? You know, the short-term kind of concern a lot of people have is saying, I don't want to be in there. We're taking the opposite approach of saying, what if you all actually want to be in there and actually you're embedding within a public model as a social media profile that you don't control? How would you have some control over your representation in those models? I think that's an interesting question for a public AI network, for example. You know, so long story short, we put together an organization called Spawning back in 2021, trying to think about data protocols and these kind of permission layers. One thing we did is build a website called haveibeentrained.com that basically allows for you to search the largest public data sets to see whether you're in there. On top of that, we built something we now call the Do Not Train registry, because more people know what that means. But ultimately, it's a consent protocol for people to register their wishes, whether they want to be in or out of training runs. That protocol is now used to the extent that there's at minimum 2 billion unique pieces of work that have consent claims associated with them, and it's integrated into Hugging Face and so on and so forth. And from this, so that's kind of the sweet thing. Reema's, I assume, going to have a lot to say about this current debate about permissions and copyright and so on and so forth. Our position was to say, hey, we get to kind of rethink IP here. You know, what if all data was available to be trained on? You know, unless she said no, right? That sounds like maybe a more permissive way to approach this topic moving forward. Some other fun things we've done in that context, we put together something called the Kuduro network, which is ostensibly an IP scraper listening network that can register and use. The more people that join the network, the more you can triangulate and understand if a scraper is there or if it's just regular web traffic. And back in 2023, we conducted a performance that demonstrated that using these kind of tools, this is kind of, you know, let's say the opt-outs are the carrot, Kuduru is the stick, you can actually shut down all training. And so the two troughs you see here are us shutting down global AI image training for 2 half-hour periods, using these kind of techniques where you can basically use the power of a network to coordinate, to force consent. Oh yeah, there's a little meme. Back in the kind of more traditional art domain, last year we had an exhibition at Serpentine Gallery in London called The Call. Worked very, very closely with Serpentine and their Future Art ecosystem team to put together what we describe as kind of a more beautiful training protocol. So we also released a book called All Media is Training Data, in case you're interested in this stuff further. But the idea of this training protocol was to basically identify that each step of the process of training a model is actually a place for creative intervention, or intervention more broadly. So from the data collection to the labeling to the model making and to the use of it going forward. Our idea with this was to first create a book, so a songbook, where if you sing from the beginning to the end of the songbook, you'll have covered the full phonetic range of the English language, sufficient to be able to train a machine on your voice or a model on your voice. We then, and here's what one of those training songs sounds like. We took it on tour of the UK.
Okay, without killing your voices. Yes, doing it again, same thing. Just try not to scream.
Here's a better one. Yeah, so we took that songbook around the UK and found 15 amateur and professional choirs who were willing to contribute their voice to a large data set. Again, I think rather relevant to the public AI discussion. Yeah, here's where they all are. And part of the idea here was to work with the Serpentine Future Arts Ecosystem Lab to pilot a data trust where each of those 15 choirs worked directly with a data delegate who could represent the interests of the data set moving forward. And so we, in training models on this data set, had to negotiate with the group. They got to experiment in, somewhat of a democratic process in terms of deliberating over the future of their voice. And we quite like the idea of piloting this kind of model of maybe collective rights in a data and AI context. And so the good news is, we, as well as building these kind of training objects and producing the data set, we use the data set to train a fully consenting choral model based on the voices of the larger group that came together, and it ended up sounding quite beautiful. Here's an example. And so here, one of the things we were trying to tie into is really trying to encourage a sense of contribution to something or submission to something greater than the sum of its parts. This is actually at least my understanding of what a public AI might be, is possibly the most beautiful sentiment that could be encouraged, and is regrettably a little out of vogue, right? We have a lot of conversations about individual rights. We have a lot of conversations about people taking things from each other, and very few conversations about actually contributing something of ourselves for the benefit of everyone. To build on that idea, so with our collaborators at Spawning, we've actually started looking back at this idea of the public domain quite a lot. As most of you maybe will know here, it's rather outmoded, right? Most people now post to kind of 5 companies who have irrevocable training rights to that data. Public domain hasn't really been updated for many, many years. It's not a resource that's being replenished. So we've done a couple of things. One, we released PD12M last year, which is the largest kind of high quality public domain image data set. There's 12 million really high quality images in there. We're actually going to update this and release like 15M soon, because we have far more. And then currently what we're doing is we're training a model called public diffusion, which is a fine-tunable foundation image model trained only on public domain data. Doing this really to test this idea and this thesis of saying, could you train a solid enough foundation model to be useful for people that could then be built on by others in domains that it knows. So it turns out, no surprise to anyone, there's loads of paintings of mountains in the in the public domain. It actually looks as good as state of the art. What is regrettable in some sense is that my favorite example here is there are no corgis in the public domain. So this model will not be able to tell you what a corgi is, right? So if you wanted to build a big public AI network, you might start with a corgi as your mascot and encourage a bunch of people to put corgis in the public domain. So this is a website you can find out about more of our projects. You can also go to spawning.ai. And yeah, I'd love to talk more about this question of public data, public domain data, because we're actually doing a lot more projects on that going through this year. But I hope I hit my time and that was somewhat coherent.
Matt, that was great. I'm so inspired by honestly everything you presented.
Thank
both
you.
the kind. The thinking that's clearly gone through it, but also the form it's been realized in. It's spectacular. Let me get us kicked off then with okay, I kind of have to dig into this, like that one slide on the Kuduro network performance. So wait, what exactly do you mean you shut down global AI training? So it's like on
image training,
a specific website, image training. So like what was the sort of contour of that experiment? Like how many websites were involved?
So long story short, we're actually releasing like a short film on some of these at the moment because the details are actually really fun. But basically, if anyone's familiar, there's a researcher, a kind of security researcher called Nicholas Carlini, who's wonderful and has released a bunch of amazing papers on data poisoning, basically security of vulnerabilities in machine learning. He released a paper in late 2022, I want to say, that pointed out a potential vulnerability in AI training, which is ultimately kind of like link injection. So you have scrapers out there who are pulling from billions of sources, and they often don't know if the content that they're scraping has changed since the data set has been collected. And so what we did was we set up a system where we found the most popular, so the Lion image data set. We then set up bots to buy domains that expired that were included in that data set. And each of those domains then we knew were going to be used by companies who are quickly just looking to grab as much data as possible. And so basically when a crawler or scraper is looking for an image, we then have the ability to register their IP address through that image that we now own, and also feed them what we want. And so what the way the network works is we have, I think it's like over 1,000 of these websites. When a scraper comes through, we can identify and say, look, what are the chances that a regular human would be going to this website, this website, this website, this website, this website in the same 5 minutes? Basically zero. This is absolutely a scraper using this. We can then alert all the other websites in the network to shut down that IP, so to not allow them there, and you can run attacks. So in our case, I mean, we were initially interested in poisoning in terms of like subverting embeddings and so on and so forth. Turns out you can't do that, but what you can do is like a tar pit attack. You can change an image from being 100 kilobytes to 100 gigabytes, right? So that scraper is just going to be downloading. So it's a vulnerability in image. Now, the reason we were doing this, one is it's a pretty cool performance, because you can basically just have them spin their gears. If we'd have left the network on, I mean, we had people from Common Crawl come and speak to us and say, hey, we saw that too. Like you can do a lot of damage with these techniques. It wasn't our intention to do maximal damage. It was more our intention to kind of burn fingers and demonstrate that absent a kind of commonsensical approach toward, let's say, data manners, right? Coming up with some kind of consensual protocol where people say, hey, you can have all this stuff, maybe observe opt-outs. This is the world that we're likely moving into, which is a more antagonistic, adversarial environment where people are going to be attacking each other all the time, sending each other on. So our idea there was more to demonstrate, we don't actually want this future. This is kind of an example of why we need commonsensical data permissions systems going forward. That was the idea.
I have so many questions. First off, let me open it up. If there are any questions, please do raise your hand. In the meantime, wait, why can't you poison it? Is it just because they're getting too much data and it statistically doesn't really matter?
So it turns out, so for example, many here will know of kind of, there's been a few experiments where people have actually had run-ins with, like, glaze and nightshade. There are some famous kind of data poisoning experiments that I think were largely overblown in terms of their capabilities. We could poison using this technique, but it would have to have been like a blunt force trauma poisoning attack. We were more interested in, for example, saying, can you use this technique, for example, to subvert embeddings, right? Could you, for example, give a bunch of images, let's say we own 1 million images in this data set, could we dedicate those 1 million images to, change Holly from having red hair to blue hair as just a test, right? It turns out that the way it works, the captions associated with the links are fixed. So we could change the content in the links, but we couldn't change the captions associated with it. So then we're like, okay, that's done. What you could do for poisoning, however, is you could take those 1 million images and make it all the same QR code, which would work it hypothetically would work like, have you ever seen old screen burn? Where, like one image is kept on a really old TV screen for forever, and then that TV screen has it kind of just burned into itself. Hypothetically, you could poison. But what was interesting here, and actually I think this is interesting related to the public conversation, is that in order for that kind of poisoning to work, you really would need a large group of people to coordinate and have consensus on one attack, right? So the other proposals that have been put out, let's say by the Glaze team, which were largely fictitious, regrettably, is, you could just, a decentralized group of people could all poison their images and put them out in the world, and then that would magically, damage AI models. It's wishful thinking. It's more complicated than that. If, however, you did have 1 million people who agreed on one attack, you could do a lot of damage. Not advocating attacks here, but rather saying with this carrot and stick approach, networks can be powerful with coordination power, right? And so it's actually the network, these cat and mouse games, when it comes to more adversarial tactics, once developers figured out what we were doing with that attack, they would route around it. And then you could figure out another way to do something, right? But ultimately, it is that kind of consensus and coordination mechanism that gives you maximal options in conducting an attack or conducting or running something secure. And actually, Cloudflare, interestingly, has actually implemented something I think rather similar to Kuduro recently this year. And of course, they're in a really big, strong position to do that because they run traffic through a lot of the internet. So I'm really curious what they're doing in those cases too. But I'd imagine it's closer to some of those listening capabilities that we would have of saying, okay, well, what are the chances this IP is coming, is hitting these 60 websites at exactly the same time? Very minimal, right?
That's awesome.
You go.
Yeah, I imagine that this is going to be something that I bring up a lot in the seminar, so I'm excited to learn from all of the different perspectives, both the presenters, but also the other members of the cohort. But something that I think that your work and the work with Holly Plus, I think really kind of teases out is the difference between consent from a training data contribution perspective versus consent from a kind of industry disruption perspective. So there's two harms that people tend to talk about when they talk about AI, particularly as it relates to artists, although I would argue that maybe we should expand that to like everyone whose labor it might be impacted by automation. But there's the like, hey, I didn't give you my voice data or whatever, right? And I think that that's important. As someone who's advocated a lot for privacy, oh, I should have introduced myself. I'm Bea Cavallo. I lead emerging tech at the Aspen Institute, but I also used to work as a congressional staffer. The primary thing I worked on was the Algorithmic Accountability Act. So like very, very interested in kind of like what are the modes that are available to us. But one of the things that I think is challenging is that one of the things that many of the Glaze type protests, one of the things that motivates those types of protests is not actually necessarily about the training data. It's about the idea that downstream work will be devalued. And what I anticipate and what, examples like the public diffusion, which is really interesting and exciting, seems to suggest is that like a bunch of consenting people might be able to make a model that then does totally disrupt the market for a particular skill set, and like how do we navigate consent in that space? So I'm just curious how you all have navigated that, recognizing that that maybe there's no solid answers on that, but it seems like something you've been toying at the edges of as well.
Thank you. Yeah, that's interesting, and totally the point. I mean, just to put our kind of priors out there, we're incredibly pro AI and see consent as kind of a like a fundamental characteristic of how relations work in the future, right? So we're not, let's say, in a position. I mean, I'm actually. It should be stated that the work of ours that is included in data sets, we are completely content with that being used for any purposes. We have no. The point being is that there's loads of people who aren't, and I think that they should be listened to. The idea here is that we actually see consent and rethinking IP as a welcome opportunity to kind of maybe even expand the notion of consent, right? When we start talking about embeddings, for example, I think that the idea of getting to be who you want to be on the internet was pretty foundational to our understanding of the internet, and is something that is often omitted when we talk about AI, right? There's this focus on truth, right? On which is for good reason, like in some journalistic cases or whatever, but it is kind of unusual in the sense like what externalities there are to these kind of the conversation about consent being so narrow or so narrowly focused on, let's say, copyright, right? Another idea here that we've explored a little bit but haven't done too much work on is the idea of, let me catch my thought. Expanding consent in the sense of saying, okay, let's just suppose that we are entering into a world in which you are able to assume the identity of somebody else or assume the IP of somebody else for one reason or another. What are red lines around that? Consent in an automated environment can actually be far more detailed than a simple yes or no, right? In the sense of saying, in an agentic environment, you are very happy to use my, you're very welcome to use my face or voice, but please don't do so in this context, right? That actually in agentic kind of or in automated environments, there's a lot more you can think about building in terms of building and overseeing data or identities or whatnot that isn't really being thought about, because we have this rather like maybe skeuomorphic understanding about what the next information substrate is going to be like. We assume it's going to be like prior ones, and I actually don't think that that's true. And so if anything, our position, which sometimes confuses people, and is that we actually want on maybe a policy level, like maximum optionality to not make too many kind of hard or crude decisions at this particular point in time, foreclosing possibilities to explore more interesting IP in 5 years, right? And so yeah, so it's we find ourselves in an opposition, and I actually do have a lot of sympathies for people who are kind of caught in the washing machine of moving tech and people kind of moving fast and breaking things, but fundamentally do fall on this. I'm kind of into AI. I'm not really necessarily afraid of it. I think art is much more resilient than people give it credit for sometimes, but would on a policy side recommend maximum optionality moving forward, because I think that there's plenty of consent mechanisms that could be explored in an automated environment that actually far exceed people's choices in the current paradigm of shaky copyright laws and so on and so forth, right? So whichever way you cut it, whether you choose to be very, very non-permissive or very permissive, I think there's going to be more options moving forward. It's just important for courts and governments to not kind of step into these areas with too heavy of a hand. And to your point about public diffusion, I mean, I'm under no kind of I'm not naive to the idea that this model will end up will be competitive in contrast to state-of-the-art models, even since we started training it. Like the new GPT image model is just sorcery. It's like completely, but rather prototyping these kind of modes where you're saying, okay, what if there was a large amount of data that was available to everybody, and we were able to coordinate and kind of create systems for our own purposes. What would that look like? The best place to start is to train a diffusion model for not ultimately a huge amount of money, and then see what possibilities lie there. So I think it's still important to do that work, even though I'm not under any false understanding that it's going to be the most successful commercial model in the world or anything. And we don't need state of the art for most stuff. For narrow applications, absolutely. Yeah.
I guess I'll jump in. I think my question built on this. My name's Andrew. I'm the managing editorial director at Rebind Publishing, where we're trying to figure out how to publish books post AI, so to speak. So my question is, I was really interested in specifically the kind of like royalty structure, for lack of a better term, for both Holly and then which you detailed as, if I remember correctly, 50-50 split between kind of original creator and then like secondary creator, maybe we could call it that, and then the process that you went through with the choirs. And I think trying to get to like a specific question, but I'm both interested, I think, in the process that took you to kind of whatever those final deals were, kind of like what are some of the things you were thinking about and grappling with, and then also maybe like learnings moving forward in terms of like what you would do different maybe, and then also just like the scalability of some of this stuff.
Great question. Yeah, I mean, Holly Plus, that we did that in 2021. The idea was a little more convoluted than even the slide, where it was a 50-50 split between the spawning. So we came up with this kind of term spawning to differentiate it from sampling, because we see using these models as more reproductive than kind of rote. We just looked at the 50-50 rather to kind of give a good deal to the group of people who were using the model. And actually, it was kind of 50, 25, 25. We'd initially put 25% of that into a collective pool of royalties for maintainers of the model. But I've removed that slide for most purposes, because most people aren't interested in that detail, but this group seems like they'd be interested in that detail, which is also thinking about like intergenerational kind of stewardship on this, which I think is also interesting if you're thinking about a public identity or whatnot, right? That it's kind of interesting to see a large group of stewards of a data set or an identity or something like that as actually kind of having funds available to maintain their interest in something going forward. In terms of the choir data, which is kind of more updated, we haven't really got a royalty structure in place. So there, what we did is we put together the group. We funded, along with Serpentine, we funded the whole project, and in return for putting this together, they granted us the right to use the data and the models moving forward, but kind of bookended for that project specifically. So we agreed and kind of negotiated with them in kind of a pet test. Our recommendation to them was that they actually open the data, give it to researchers, but they're still deliberating about what they want to do with it. And so ultimately that's kind of their choice. And I would guess that if there were licenses negotiated, ultimately that would be up to them, right? That there would be a price. The real danger here, and I think this is relevant regarding the books conversation, of course, because of like the meta like libgen debate at the moment, is with spawning in particular, we've done a lot of work on this of thinking about pricing data, and it's a really a wicked problem. Regrettably, as much as I understand that the legal teams behind the AI companies are relatively strong, they also really do have a point here. It turns out that almost all data in this context is relatively fungible. And it's really important for people to know that, right? If you have 100 images in a 5 billion image data set, or you have one book in Lord knows how many are there, which is very, in a way, it's a wicked cold shower to accept. The Aretha Franklin song is going to be worth as much to a model as a random song from YouTube. It's very offensive in the sense, it's a horrible thought, but it is somewhat true. And I've definitely spoken to people who are like, look, to us, a token is a token is a token, right? In this particular narrow domain that this data is taking on, it's rather wicked. I think that, but that is not to say that data is not valuable in this scenario. I think that particularly in the realm of books, one of the things we're working on a lot at the moment is this idea of kind of context sharing. So rather taking this assumption that all media is training data, thinking of ways to better package context as something that is shareable and potentially a service that can be provided. I think there's all kind of new interesting applications for commercial services that creative people can offer that are very native to these scenarios. And then you're not talking about making 5 cents being part of a billion something data set. You're actually talking about a different way to engage with a creative person. Still very early to talk about here, but our strong feeling is that the only way out here is through, and that actually exploring ideas like context, bespoke models, whatever, is ultimately, there's a lot there, but we kind of have to move into that conversation rather quickly to be able to test it at scale. Just to see what works, because some of it might not stick. I don't know.
All right, perfect. Hi, folks. Welcome back to the second part of the, I guess, first session of the third season of the Public AI Seminar. It's my pleasure to have Reema Selhi join us, who is head of policy at DACS, has a whole list of institutional affiliations, which are all very impressive. I'll just name one, the board president of the British Copyright Council. And look forward to hearing more from you, Reema, about, I think, a big section of the earlier conversation was about copyright, and I think this is a great opportunity to just go straight and dive deep. Welcome.
Brilliant. Thank you so much, Josh. I'm going to share some slides as well. Yeah, thanks so much for having me. It's so nice to be here. Let's see if you can see this. Can you see anything coming up for me?
Not yet. Oh, there we go.
Yeah.
Now we see.
Working. Is it working? All right. I will make sure it's on the right view. Yeah. So as Josh said, I'm head of policy and international at DACS, which is an organization that represents the copyright interests of visual artists. I'm going to go into this view. Hopefully that's nice and clean for everyone. Yeah, so DACS represents copyright visual artists. We've been around for 40 years. We had our 40th anniversary last year. And much like a lot of copyright societies that you have for music and writers and others, effectively we license the copyright for artists, image rights holders. So that could be photographers, photo libraries, fine artists, illustrators, and so on. And because copyright lasts for an artist's lifetime and then after their death as well, we also represent the estates of artists too. So what I want to talk about today is AI and copyright through 3 different perspectives. And effectively, this session is going to be, or my part of the session will be kind of information and then provocation. I think it's really important to think about the legal perspective of copyright because it's become such a big part of public debate around AI, but I think maybe sometimes the finer detail around the law and maybe how the law in different countries works in different ways has quite an impact on our understanding of what's at stake. And then also sharing some of the artist perspective that we have from our own members. So we've done quite a lot of work with our members through surveys and workshops. So we do actually have some nice little snippets, whether that's stats or quotes from artists that I wanted to share today. And the final part, which is probably where it will get a lot more interesting and relevant to the conversation that Matt also, that brilliant conversation that Matt just started with us. We'll be looking at kind of what's the policy making agenda and where does potentially the UK get it a little bit wrong. So yeah, it's a little spoiler that I'm not entirely happy with the policy making agenda of the UK, which is where I'm based. So just in terms of the legal perspective, this slide is just to show that, you know, copyright is just one of the many different types of intellectual property rights that a creator or even a company can have. And I've highlighted that as being the one that we're going to talk about today, but just also so that you're aware, there are also more commercial rights, such as trademarks, which a company would have more to protect their brand, design rights, which protect sort of 3D, you know, that could be anything from like furniture to washing machines. Patents is a much more industrial application around innovation and invention in kind of design and also pharmaceuticals. And database rights is actually quite an interesting area, which I think has really been kind of overlooked, but could be quite useful in the AI conversation, as this is a right that protects kind of a database or a list or a catalogue of certain types of work. So, you know, that could even be sort of a catalogue raisonné of artists' works could be protected by a database. But just to kind of give the quickest overview of UK copyright law, and hopefully this won't put you all to sleep, given it's, you know, probably the afternoon for some of you. And it's an area where, you know, there's a huge amount of study that goes on in copyright law, and this is really going to be such a distillation. So by no means kind of exhaustive in any way, but I thought it would be good for us to just at least be on the same page. Copyright is in the law of like almost every country in the world, but every country has an ever so slightly different way of doing things, with some jurisdictions being really completely different to others. So this is a sort of UK view of what copyright is. And it arises the moment you're creating something in a fixed format. So it doesn't protect ideas or necessarily style, but it protects an actual kind of expression of that idea or of that style in a fixed way. And that would be any kind of visual work, musical work, literary or audiovisual or performance work. So actors, for example, also have kind of copyright in their own performances. And it lasts for the lifetime of the artist and then 70 years after they've died. So that's the reason why we also represent a lot of sort of the estates of artists as well. And copyright effectively is it is monopolistic in the sense that it does give an exclusive right of the author that arises the moment that you've created this work in the fixed format. And that's an exclusive right to permit or deny what we call one of these restricted acts. And those restricted acts include reproduction, so a copy, making available or communicating the work to the public. So that's distributing it. And then the author also has this right to license the use of any of those uses for a fee. So I think that's quite an important thing to remember. What we're talking about is when we talk about copyrights, that we're talking about the exclusive right that an individual has, or maybe even a company might have if the right has already been assigned to them automatically. There's also moral rights, which do come up quite a lot in the conversation around AI and copyright, especially in the sense that artists or creators of any kind have a right to be attributed as the author of that work. And that kind of crediting aspect of someone's work and someone's identity does come up quite a lot as something that people feel kind of concerned that they don't get credit for the type of work that they've done that might have contributed, for example, to AI training data sets or even generative AI outputs. There's also often a talk about, you know, do you need to register your copyright? In most of the world, you don't, and it's definitely not needed in the UK. But I just wanted to flag here that the registration in the US is really for very specific benefits. So it gives you much more kind of better rewards through enforcement of your rights, but it isn't generally a prerequisite. Copyright just arises the moment you have made your work. And then exceptions, again, a very big part of the copyright and AI conversation. And this is where like the idea that the law might need to look different kind of hones in on these exceptions to copyright. And that's the situation where the work is used without someone's permission. So for the most part, the way we've looked at exceptions in the UK has been on a kind of case-by-case basis that balances the interest, this monopolistic interest of the author, with something like freedom of expression or the ability to criticize and review someone's work. So it's always this kind of balance between the two. And it's exactly that balance that the copyright law debate around AI is trying to get right. Like, do we need more exceptions or do we need more protection for artists? There's a lot of AI lawsuits at the moment, mostly in the USA, and that's, I think, quite specifically due to certain reasons, such as maybe a slightly more litigious nature, but also trying to identify whether or not there's an infringement of copyright. So have one of these restricted acts happened without the authorization of the content owner? And also, has it happened where an exception doesn't apply? That's effectively what an infringement is. And this, the two photographs I have on this slide are from there's only one case in the UK at the moment in front of the courts, and that's the case that Getty Images has taken against Stability AI. And I've taken these images from Getty Images' claim, which is to show that, well, it's their way of trying to show or make their case for the fact that an infringement of copyright has taken place. So to try and unpack what they're trying to do here, what they're trying to establish, is that they're saying effectively there's either been a copying, a distributing, or even an adaptation of their work or work that they hold rights in without their authorization, and that an exception under the law can't be relied upon. And in the UK, this is a test that can either look at the whole of the work or just a substantial part. So, you know, going back to this, there might be aspects of this where Getty and their lawyers will very carefully try to claim what might be considered a substantial part under the kind of remit of our legal framework. So this can get very kind of complicated, and there's quite a lot of aspects of a claim that would need to be unpacked. Although for the most part, I think when you hear kind of legal news reporting, it might sound quite sort of binary, quite black and white. I think there is always going to be a lot more to unpack with these cases, which will effectively have quite a wide impact on sort of how we think about AI and how we think about permissive uses of copyright. Now, I just wanted to really highlight some of these national variations, which again means that we have to be really careful with kind of what we see and read. For example, in the USA, there's this fair use doctrine, which is an overarching exception to copyright. And fair use as a phrase gets bandied around quite a lot to kind of mean a permissive aspect of copyright. Although, unfortunately, fair use isn't actually a doctrine that is in the European Union or in the UK or in a lot of other jurisdictions. It's quite specific to America. It's quite a broad defense, which requires quite a subjective test. So that's one of the reasons why I think there's an awful lot of litigation in the USA at the moment, is that fair use is quite hard to define. And so there's a lot of different cases. I think about 20 cases are in front of different state courts and in the US to try and test this idea of fair use when AI training has taken place. About a month ago, we had an early indication of how the courts might be deciding things. This is a case called Thomson Reuters and Ross Intelligence, which was heard in a district court in Delaware, and the fair use defense was rejected by that district court. So effectively, they said it wasn't fair use for Ross Intelligence to be using Thomson Reuters material for AI training. So I think that's going to be one to watch. I think that will probably be appealed, and it might also have quite an important impact on some of the other cases coming down the line. In the European Union, there was a directive in 2019 called the Digital Single Market Directive, and this introduced a broad, what's called text and data mining exception. Text and data mining is considered to be the type of activity that happens when AI training takes place. So a large swathe of data, whether that's text or images or even visual or audiovisual work, sorry, I should say audio or audiovisual work, is mined for a certain type of use, and that could be also a commercial use. And this is where the European law kind of broke slightly new ground, because usually the doctrine of copyright is that you have this exclusive right unless the exception applies. Whereas this kind of inverted things from a sort of almost philosophical perspective for copyright, that the exception was the default unless you opted out of it. So I think that was kind of one of the first times we've seen this exception be the standard. So it's a really broad exception, which is standard for AI training, unless you, as a copyright holder, have made a certain action. And I just wanted to kind of leave that there as something we can maybe think about from also a philosophical or academic perspective of, are there different ways of doing things from the way that we've always done something? Because I think the EU's approach to this, flipping copyright on its head, as unwelcome as it has been for many people, I think at least shows that there could be new and imaginative ways of thinking about our legal framework. Then coming just to the UK, because that's my jurisdiction, and I'm not sure how many people are from the UK here, but I have the most knowledge about this area because this is the area that I've kind of qualified in as a lawyer. That specific copyright exceptions exist, as I mentioned before, for certain purposes. And it's always very specific to kind of create that balance so that users have this benefit of something which is kind of a monopoly right for very certain purposes. And one of the aspects of this certain purpose is that the way in which you use that has to be done for a fair dealing, not fair use, but a fair dealing reason. So, for example, if you were doing kind of using the criticism and review exception, the point at which you might start to really commercialize your critique or your review of something, the fairness starts to fall away. So again, like that needs to be dealt with on a relatively subjective test, but it kind of shows that there might be a limit to like what we consider a fairness or, you know, a kind of good faith use of someone's work. And this is exactly where our government, the UK's government, is consulting on whether to follow the EU's approach, is whether or not they take on that text and data mining exception, and if so, how. So just moving on to artist perspective, in 2023, just towards the end of 2023, we did a survey of artists. We asked them a series of questions on artificial intelligence, not just their use of, not just AI training, but also their own use of AI in their work. Actually, we found some really interesting things about a lack of skills in AI, which I think was an area that I'd love for, you know, there to be more conversation on rather than just on the copyright aspect. But here we are, we're talking about copyright. And we released a report in January 2024, and this is just some of the statistics that we got from the survey. I think we had 1,000 artists exactly responding to the survey, so lovely to have some nice numbers. We had 96% saying that they hadn't given permission for AI models to be trained using their work. There was a great support for being asked, being credited, and being compensated when AI was trained on their work. And then here's an area which I think was super interesting because it really goes to some of the work that Matt has been doing around have I been trained and spawning. So in our survey, we asked artists participating in the survey, you know, can you use spawning, can you use have I been trained to see whether or not your work has been used for AI. And I think the fact that quite a lot of people didn't know if they had or not, or if they couldn't identify it, was the fact that a lot of artists' works can be quite publicly available, or, you know, they might go on display in a gallery. People might take photographs of them. It's probably quite difficult for people to really know, how does an AI company actually access my work? Where did they get it from? Where's that data set? So there's a few kind of missing links, I guess, in terms of just being able to see whether or not one image might have been used for training, to then really knowing kind of where are all the access points for my work generally, and is there something more that I can know and more that I can do? So I think this led to kind of quite naturally to the idea of there being kind of a veil behind, you know, a veil in front of all of the kind of AI activity, AI training activity that really could be lifted, and to leading us to kind of the idea that policy around transparency measures would be really welcome. There was also some kind of questions around what about style prompts? So, you know, ultimately copyright doesn't protect your style, it just protects the work itself. But an infringement can, as I've mentioned before, be kind of a copy of a substantial part of a work. So here's just an example of one that we did ourselves, which was kind of looking at David Hockney's work and then kind of style prompting a painting in the style of David Hockney, Pool with Men. And then there are obviously some elements here which probably wouldn't necessarily pass an infringement test. But the only thing I think this does show is kind of, but for those David Hockney works being available for training, what kind of image would you be getting from prompting that prompt? Would it look different if those images hadn't been used in training? Coming on to kind of what's the impact from an artist's perspective, quite a lot of them were concerned about their style being mimicked in a way, with a lot of artists giving us kind of testimony about how the style that they kind of create their work in is kind of their USP, that's their selling point, especially if they're illustrators or designers or some people who kind of work with businesses to create something commercial, that their style is sort of what a lot of businesses will go to them and commission them for. So this is a quote that we had from the survey, which is where someone who was an illustrator felt that they were going to be replicated through kind of AI technicians in the workplace, replicating the style of the illustrations they're making for the company. So the final part of this, I just want to go over the policy perspective in the UK, because this is where I think things can get a bit more interesting, and hopefully we can have a discussion around this. This is to show you also the kind of timeline that, you know, the government hasn't only really just started looking at AI, but it's been a bit of the AI copyright quandary has been going on for quite a few years now. So in 2021, we had a Conservative government who announced this consultation on AI and intellectual property quite broadly. So it looked at patents and trademarks as well. And we were concerned that they were proposing quite a wide text and data mining exception, so just what the EU had, but without having an opt-out at all. And unfortunately, despite quite a lot of evidence demonstrating that that would be quite harmful, the Conservative government did announce plans to introduce that. But a couple of months later, they reversed that plan. They felt that actually the kind of department in charge of looking at it hadn't really considered evidence of how lack of opt-out would kind of limit control and limit kind of creators being able to decide what they could do with their work. We surveyed our members in between the kind of two governments, and then in 2024, a new Labour government was formed, and quite early on, they suggested that they wanted really to harness AI and for AI to be kind of a big driver for innovation and growth in the UK. And then December last year, they finally launched a consultation focusing just on copyright, and that proposed 4 options, which I'll go into in a moment. But before the consultation had closed, the government also released an AI Opportunities Action Plan, which was endorsed by the Prime Minister. And that suggested that copyright was a barrier to innovation for AI companies, and suggested a reform of copyright as well. So going into the consultation, the 4 options that were proposed were really only 3, because the first was actually to do nothing. With the others being quite binary, I think, in many ways. So you could strengthen copyright requiring licensing, go for the broad text and data mining exception, which the Conservative government had also proposed, and then rode back on. And then the government stated that their preferred option was this final one, a data mining exception allowing a rights reservation, so effectively an opt-out, underpinned by measures on transparency. This is just a little bit more detail about what that would look like. Our approach to this was to hold some workshops with artists, lawyers. We had museum and gallery representatives, which was led by Convocation Research and Design, the very wonderful Caroline Cinders, who, if you guys don't know her, you should know her. She's brilliant. And we looked at a few different aspects, like how would an opt-out actually work in practice? What would the costs be to an individual or even an institution to kind of identify where works had been used and potentially opt them out? It also looked at harmful design patterns. So Caroline's work previously had been on dark design patterns for data use, which is where an individual's choices and actions have been limited through kind of misleading design baked into hardware and software. And then finally, we developed a kind of 10-point transparency model, which would allow granular and accessible information to rights holders. So really kind of building on this question that we had from from our survey previously, a lot of artists finding it not completely clear whether or not they would even know where to look to see if their works have been used for training. This transparency model kind of built on that a bit more to encourage AI companies to demonstrate kind of on a work or title basis and access basis where the data sets had been found and had been used. So our recommendations ultimately were for better transparency that could lead to licensing rather than having that opt-out and text and data mining exception. And the report is there. I just wanted to add in this slide because I think this is a good way of demonstrating visually what the kind of whack-a-mole situation is for an artist once they've made a work, especially if it kind of has a sort of viral cachet like this amazing one does. So this is our member Adele Morse, who, and this is her taxidermy fox, which became a kind of viral meme, stone fox. And obviously not everyone's work will go viral, but this is an example of you know, how difficult it is for her to really know where her work has been used because it has been kind of copied and adapted in so many different ways. And even if she's happy with those copies and adaptation, because I think in some cases she really does see this as being kind of like a lot of her fans really, really engaging with her work. But it does demonstrate that, okay, if there are copies of her work made by her fans or made by other people, even if she were to opt out some copies that she's got of her work, it would be very difficult for her to do that for all the other people who've used and shared her work. So effectively, once something's out there, it's quite hard to control, which means the opt-out does become really kind of difficult to achieve. And now this is a bit where I start to kind of be a bit more spicy and talk about where I think there were some concerns that I had with how this consultation approach went. Firstly, the fact that, you know, was it really an open consultation when the government already suggested a preferred option and when an AI action plan had come out, you know, endorsed by the Prime Minister that suggested a very specific kind of approach to copyright. The options were relatively limited. We had one option which was doing nothing and one option which was repeating a kind of conservative government's approach, which had then been reversed. So you only really had two kind of valid options there. Concepts like opt-out and transparency might be clear in concept, but there wasn't really any detail on how the measures would be achieved. The EU system was seen as a preference, but the opt-out issues, like I've shown with Adele Morse's Stone Fox, haven't really been solved. There isn't really a sensible proposal about how opt-out would kind of work in practice. Also, there was about 11, almost 12,000 actually, responses received, and I think there was a lot more than the government departments were expecting. So obviously there's going to be a long period of time for all of these to be analysed, and if the result comes out quicker, then perhaps they may not be analysed in great detail. And we also don't really have any detail on what the next steps will be. Before I finish off and we can talk a little bit more, these are kind of my provocations. So my final thoughts and final provocations are over really what is it that we're trying to achieve? If we want to enable kind of more AI training, then do we need a fundamental shift in copyright law to do that? Or are there other ways that we can enable AI training? Do we need a shift in copyright law to enable more control for copyright owners? Or is there another way to do this through kind of non-regulatory or non-legislative mechanisms? I think Matt mentioned, or someone had mentioned, the Tony Blair Institute idea of a levy. We've also at DACS been talking about levies through a campaign called the Smart Fund for a couple of years. as a way to kind of bring equity, which doesn't necessarily need a license or it doesn't need infringement of copyright to take place, but seeing their overall value in an artist's work and levying on devices or levying on ISP providers, for example, could be a way of bringing this. And also something that I really think could be an aspect for a kind of public AI conversation is that ultimately with copyright and AI consultation and copyright and AI debates that keeps raging in the news and in Parliament, is that ultimately it's a balance of two private interests. So it's the private interest of the copyright holder, so that whether that's a musician or a label, or on the other side, an AI company or anyone who's doing training. These are not public bodies. They are two private, sort of, they're private interests. But nothing in the consultation or in the ideas that has come about really talks about what's the role of the state. So there hasn't really been much conversation around types of regulatory measures or a regulatory body that might have a certain role to kind of police or provide redress, or even provide, you know, some kind of like connection between the different private interests. In terms of accountability, again, a lot of copyright infringement avenues of redress is through the court. The UK has only one significant AI and copyright case going through the courts, but it doesn't necessarily mean that smaller entities or individual artists would have that same level of redress. It would probably be really expensive for them. And again, with transparency, we don't have any kind of public provider that will enable, that's there to kind of play the role of enabling transparency in a way that could benefit both parties. And then finally, just before I kind of finish off, I think it's also a missed opportunity for kind of the AI and copyright conversation to happen in such a vacuum. Not only is it kind of devoid of the other IP rights, but it's also devoid of other rights like data rights that are often kind of used together at the same time. When you have, for example, an image, you might have the data rights of the image maker as well as their copyright. But the kind of the way that public policy seems to be working in this space is to kind of divide and conquer. And I think there's a missed opportunity to talk about them on the whole. And that's pretty much it. So yeah, happy to hear thoughts.
Reema, thank you so much. This is a, oh my gosh. That was incredibly rich. And I'll say as a lawyer, a lot of new information. So I'm trying to still process it. Maybe the thing I want to kind of lean into a little bit is, I think this is kind of a spectacular segue into the theme of the seminar, which is about artists, about the creative industries, but also not just about like how we create art, but how do we create effective political action, right? So we're talking about copyright law, which is a kind of policy that we could potentially change. You're in the middle of representing artists in this, you know, negotiation with the government effectively, right? Maybe like one thing I would just broadly ask is, if I were an artist, where I'm like, even just as part of this, like, what is the best way of making stuff happen? How do we get, let's just say in this case, the UK government to pass bills that support artists' interests? Is it something that, you know, grassroots momentum helps? Or is it something where you need, like, I don't know, the UK like movie industry to sort of get behind it? Like, what is actually useful? Like, what will actually move the needle?
Yeah, I mean, I think one thing that's happened, especially, you know, one of the reasons why there's so many responses to that consultation is because there have been some really big campaigns going on in the UK. And some of them are quite sort of entrenched in a certain voice. So it's very, very kind of protectionist, that we need to retain copyright as is. It may lack a little bit of nuance because that's often how very public campaigns have to be. A lot of the kind of major IP holders, so production companies, film studios, newspapers, those who ultimately don't always pay the creators that work with them, will often be at the forefront and have the money to spend on very, very kind of public big campaigns. I think those have some merit in the sense that, you know, their governments will often listen to big players and big business. That's just kind of how it works. And, you know, to have some big businesses align themselves with smaller business interests, it can be good to piggyback. But the reality, I think, is that saying no to a change in copyright law will only get us half the way. It can only do one thing. It doesn't necessarily, and again, this is similar to this consultation process, a highly unimaginative, black and white, sort of siloed set of questions. There isn't really enough developed thinking around what's the alternative, what's the way in which we can move forward with something that works for all parties. I mean, this notion of transparency, which I felt kept coming up again and again with our members and with the workshop that we were doing. Ultimately, people just wanted to have a bit more information. You know, we have that in data law. You can do a subject access request if you have, you know, if a company is using your own personal data. This kind of black box way that you know, people perceive AI to be a complete black box. Yeah, there isn't really much of a movement from the copyright industry towards how do we facilitate that transparency? How can we ask for a better public infrastructure of AI? And I think that's for me what's missing. It's too much monopoly versus monopoly and not enough like public thinking.
I'm going to put this out there. Okay, actually, I'll defer to B.
Well, now that the suspense is there, we got to hear what you're going to say.
Oh, I'll just sort of say, okay, you know, there's a lot of work in the background, which I'm not going to share here because it literally doesn't fit, of, you know, building public AI across a bunch of different countries, organizing. I mean, there's already a lot of efforts around data commons. And my sort of hope is to, you know, obviously I'm more of a computer scientist and I think about like, how do I protocolize these kinds of like copyright approaches for like figure out how do we, you know, prototype new kinds of copyright law within these commons, right? And I think that's a much bigger picture slash a very complicated thing that sometimes like you kind of have to start thinking like, how do you even prototype law in general within these kinds of like certain kinds of domains, because it looks very different. But something I just want to kind of drop that as something I would love to, you know, double click on, perhaps even after this conversation, this seminar, as in like, this is like a urgent thing that I would love to sort of develop, because I'm, you know, effectively pitching this to governments already, right? And I would love to, yeah, just source some fresh ideas. But yes.
Thanks. I was curious, and I know you talked a little bit about some of the kind of survey design challenges of that consultation. So what, I guess twofold. Like one, I'm interested to know, did the consultation ask people why they were concerned about these issues at all? Like why do you care if someone uses your style, or why, you know, I'm curious if there was any kind of background on that. And if not, in anticipation of that, is there interest, or like would you be interested in potentially trying at another consultation, like doing it over the right way or whatever, like maybe not even centered. I know that the C stands for copyright, but like not centered on copyright. Some just to a little bit self pitch here, but I lead the emerging tech team at Aspen Digital, which is one of the programs at the Aspen Institute. And we're doing some work that's around trying to align AI research, so like the future of AI, to things people actually want to have happen in the world. And one of the constituencies, one of the voices that we think is really powerful in this is artists and creatives, because they are people who often specialize in visioning and thinking about what is the future world that we want to actually create. And so, yeah, I'm just curious, like, do we know why people feel the way that they do? And if not, like, would there be appetite for finding out?
Yeah, I mean, I think that's Absolutely, there is appetite for finding out. I think when we held the workshops, and Tommy from Serpentine is on this call. Yeah, Tommy's here. He joined the workshop, and I think it was an amazing day because people really just had so much to say, and I kind of felt like it really could have been 3-4 times as long. And actually, what was very interesting was the immediate reaction to the consultation questions being asked by government felt completely irrelevant and unmoored from anyone's artistic practice. So they immediately felt, I don't recognize these questions, they're not speaking to me. And ultimately, if the idea of copyright is that it's going to protect the interests of those who make their money through earning royalties, then the least the government could do was make a set of questions that would speak to the people who should be answering those, right? So it kind of took a very, very kind of technical and granular approach where you did sort of need to know quite a lot before answering it, rather than just simply knowing, okay, well, I received my royalty statement and that is enough for me to kind of continue my practice, as a lot of our members say to us. They just didn't have that opportunity to say to them why having those royalties was meaningful and why they envisaged not having those royalties might impact their kind of ability to do their job or have their career. So I think there really is space for that, but I don't think the UK government made space for that in terms of its thinking, and anything that could be possibly done to encourage that space. Maybe Matt, I don't know if Ada Lovelace does things like that, to encourage that type of thinking is definitely a good thing.
I'll just put it out there that I would love to, if anyone wants to collaborate on something like that, would love to jam.
You know, I'll briefly mention part of the idea here is not just to have fabulous discussions, definitely that, but also to kind of engender collaborations, which is why I think, like, introduce yourself and feel free to brag a little bit about what you're doing, because I think a lot of people here would find it quite fascinating and perhaps even inspiring. Okay, I'm gonna actually basically just ask Abel's question. I'll let you decide whether you want to unmute and ask it yourself.
I don't know. I've been just typing away in the comments, so I don't know which question you want me to.
It's the spicy one.
Okay, yeah. So this, I think today I've been really coming back to an old classic for me, Mackenzie Walk's Hacker Manifesto, and really thinking about this distinction somehow between the hacker as the creator of sort of cultural capital and then the vectorialist who collects. So all these, the notion of the copyright and royalty payments, it really shoves sort of the artist from a person who we sort of idealistically place as part of the public into someone who actually is operating as a business and not as a public entity. Which creates an interesting, we sort of romanticize the idea of an artist as the public. And to me, the push, and I think that's what Matthew also kind of presents, is like, okay, we can now sort of make this open and the public actually becomes expressive, like everyone's an artist. It sort of democratizes the means. And that could be completely against the financial interests of most people classically trained as artists.
Yeah,
I don't know if it's not a question, it's just a
I think that's
I'm going to interrupt and just say I'm going to turn off the recording.